Hear ye, hear ye, hear ye. Supreme Court of Florida is now in ceremonial session. All we have cause to plead. Draw near, give attention. You shall be heard. God save the United States, the great state of Florida, and His honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good afternoon. Welcome to the Supreme Court of Florida and the final round of the Florida High School Moot Court competition. We are pleased to have high school teams from throughout Florida here today. We welcome the students as well as their teachers, families, and attorney coaches. We are encouraged to see such interest in learning about the state courts and the appellate process. I would like to thank the Florida Bar, the Florida Bar Foundation, and the Florida Law Education Association for their support and commitment to educating the public about the judicial branch and the administration of justice. I would also like to thank the judges in our district courts of appeal for their participation throughout the state in the regional high school moot court competitions. The teams here today had written appellate briefs and presented oral arguments in one of the 5 district courts throughout the state of Florida. The highest ranked teams in the regional competitions received invitations to participate in oral arguments here in Tallahassee. Yesterday, the 1st District Court of Appeal hosted the high school teams in preliminary rounds. Today we have the top two teams to present oral arguments before this court. Following oral arguments, our court will return to conference and discuss the outcome for a few minutes. Once we leave back there to discuss the outcome, please remain in the courtroom as we will return to the bench with some general comments from me and for official photos with each team. You will learn our decision later this afternoon during an informal awards reception at the Florida State University Stadium. If both teams are ready to proceed, we have one case remaining on the docket today. And the case is Mallory versus Smith. Are both teams ready to proceed?
Yes, Your Honor. Yes.
Ready? Okay, so let's proceed. Is anybody keeping time? I guess we are. Thanks.
Chief Justice La Barga, and may it please the court. My name is Mia Venezia, and along with my co-counsel, Ariel Lorenz, we represent the petitioner, Ms. Frances Mallory. In today's case, I will address the first issue, that the release executed by Ms. Mallory on behalf of her minor child for an activity sponsored by a nonprofit entity constituted a commercial activity and is otherwise unenforceable. At this time, I request up to 2 minutes for rebuttal.
Okay.
Ms. Mallory filed suit after her minor child was burned to death on a Wilderness Scouts camping trip. She won a judgment at the trial court level, but that judgment was reversed by the 6th District Court of Appeal. There are 3 reasons why this court should reverse the decision of the 6th District Court of Appeal. Firstly, the waiver is on behalf of a commercial activity. Secondly, the courts have consistently approved the notion of parens patriae and have ruled that parents may not waive their child's right to sue. And lastly, the waiver in this case is unclear and ambiguous, violating the reasoning put forth by the court in Murphy and Plancher, not specifying the waiving of liability even in cases of third-party negligence, and does not mention the distinction between employees and volunteers.
Well, let me ask you this. How is a camp a commercial activity? Why do you consider this a commercial activity? I would have thought this would be more of a community activity situation as opposed to a commercial setting.
Justice Quince, the question before this court is not necessarily whether Wilderness Scouts was a commercial activity, but if it was a community-based activity. We would contend that based on the court's reasoning in Applegate v. Cable Water Ski, the Wilderness Scouts was not a community-based activity because it precluded a portion of the community. According to the record, page 20, last paragraph, the Wilderness Scouts had several requirements to participate, including costs incurred in the hundreds of dollars, which included a registration fee, a costly...
Having a cost, is an element of precluding the public? I mean, it just seems to me that any person in the public who could afford whatever fee it was, just because you charge a fee does not mean it's not open to the public, but whoever could afford that fee could in fact participate. So why isn't I'm just having a struggle here with this being a commercial activity.
Your Honor, to answer your question, we would go to the court's test that they used in Keene v. Zoning Board, in which they looked at 3 elements to determine if something was a commercial activity. The first being if they limited the number of participants. The second is if they had any...
Did they limit the number of participants here?
Yes, Your Honor.
In what way?
There were only 6 individuals involved in this troop of the Wilderness Scouts, and we would contend that the costs, financial...
There were other troops, right? They didn't limit the overall number of participants in the overall organization, correct?
Correct, Justice Lawson. We would contend that the GPA requirement, the community service requirement, and the financial costs incurred with participating in this organization were limiting in nature. Now, based on the reasoning in Applegate, we're left with 2 options, community-based or commercial. A hybrid option would be up to the legislator to provide, but based on the 2 options this court has given, we contend that it would have to default to commercial because it precluded a portion of the community. Furthermore...
Is that test set forth anywhere in any case?
Yes, Your Honor, in Applegate v. Cable Water Ski out of the 5th DCA. Furthermore, this issue was raised on motion for directed verdict, and we contend that our friends at the respondents' table cannot hide behind an incomplete record when it was their responsibility at the trial court to establish that the Wilderness Scouts was a community-based activity. According to the record, page 21, first full paragraph, the Wilderness Scouts had paid employees.
Well, let me ask you, wait a minute, you said it was their, who brought the cause of action? It was your clients?
Miss Mallory did, yes.
So your clients were alleging that it was a commercial activity, right?
Correct, Your Honor. That
came... So you actually had the burden of establishing that it was a commercial activity.
Well, Your Honor, at first Miss Mallory filed suit because of the death of her daughter. It was a civil suit, and then the respondent filed a motion for a directed verdict on the grounds that they were a community-based activity, and therefore the waiver should have been used by the court and to dismiss the case, and therefore we would contend that the burden laid on the respondent to establish for the motion for a directed verdict that the Wilderness Scouts was a community-based organization.
I read Applegate versus Cable Water as saying, we emphasize that our holding is limited to commercial enterprises. Does that case, and I may have just gone to one part, are you saying that that case is broader and including in commercial activities are community-based activities?
No, Justice Periente. The court reasoned in Applegate that there is an interest in fostering community-based activities in order to prevent the dissuasion of volunteers, because we do concede these organizations are important to society.
So why wouldn't, if we held that this exculpatory clause was invalid, wouldn't it discourage organizations such as the Scouts from actually sponsoring these activities without a finding that they actually profited from the activities?
While that is the legislative intent, Justice Periente, we would contend that this organization was different because they did have paid employees, thereby rebuking the court in Zivich v. Mentor Soccer Club, which did provide support for liability waivers for volunteer-run activities. Justice Quinn stated that the legislator did not intend to permit commercial activity providers to avoid the consequences of their own negligence when children are injured. Secondly, the courts have ruled that parents cannot waive their child's right to sue, and to enforce this waiver would place an undue financial burden on both the parents and the state. As this court held firmly in Curtin v. Fields, specifically in footnote 2, parents do not have the authority to execute a pre-injury release on behalf of their minor child for a commercial activity.
But, you know, in that case, we were talking about an activity that was pretty much inherently dangerous too, correct?
Yes, Your Honor, ATVs.
You know, going to a scouting camp and, spending the night in a cabin is not some kind of activity that is inherently dangerous. And so I'm not sure that pretty much helps your situation.
Justice Quince, that actually goes to our third point, that in Florida statute 744.301, section 3C, a waiver is enforceable only when it waives liability from inherent risk. The triers of fact in this case found Sammy Mallory's injury to be a result of negligence, not an inherent risk, and therefore the waiver would not be enforceable.
So we go back to that your first argument is that it's not a commercial activity, but you're saying that even if it is a commercial activity, the waiver is against public policy unless it's unless it's part of the danger. And here, as you say, your client's child was burned to death, and you're alleged the negligence of the troop leader.
Yes, Your Honor. In
not supervising.
Yes.
We don't know what caused the cabin to go on fire, to be burned.
No, the record is silent on the exact details. However, to answer your question, even if this court were to find that the Wilderness Scouts is a community-based activity and the waiver should be enforced, we would point to Florida statute 744.301, section 3B. Your Honor, I've seen that my time's expired. May I briefly answer Justice Pariente's question and conclude?
Sure.
Justice Pariente, section 3B of the Florida statute requires a certain clause to be included in the waiver in order for it to be enforceable. We would contend that based on the record, this clause was not included, and therefore this waiver cannot be enforced.
What clause is that are you speaking to?
It's section 3B of Florida statute 744.301. It reads, Justice Lewis, in order for a waiver to be enforceable, a waiver or release executed under this subsection must, at minimum, include the following statement in uppercase type that is at least 5 points larger than and clearly distinguishable from the rest of the text of the waiver or
So
release.
it's the form you're talking about, not the content, but the format.
The form and content. Below, Your Honor, it says, in the content of the clause, it says, read this form completely and carefully. You are agreeing to let your minor child engage in a potentially dangerous activity. You are agreeing that even if the released party uses reasonable care in providing this activity, there is a chance your child may be seriously injured or killed by participating. And the clause goes on. So we would contend that it is not only the formatting, but also the substance. For the aforementioned reasons, we ask that this court reverse the decision of the 6th District Court of Appeal.
Thank you. Whenever you're ready.
Yes. Chief Justice LaBarga and honorable justices, may it please the court. My name is Ariella Rentz on behalf of petitioner Francis Mallory. I will address the issue that the trial court did not abuse its discretion in failing to dismiss juror Stone or grant a new trial based on said juror's alleged bias. Today, petitioner is seeking a reversal of the decision of the 6th District Court of Appeal for 2 reasons. First, that the 3 prongs of the De La Rosa standard for determining whether a juror's non-disclosure of information during voir dire warrants a new trial as established in De La Rosa v. Zakira are not all met. Second,
Here, though, there was a disclosure. De La Rosa case is one where a prospective juror did not disclose prior accidents, prior involvement in suits, right?
Yes, Justice
And
Lewis.
so that's not the case here. The juror said, I got a problem.
Yes, Justice Lewis, and we contend today that after Juror Stone stated that he may not be a fair juror, after that he was rehabilitated for that alleged bias that was brought up.
Well, how do you tell? How do you make that decision? The juror first says, I can't be fair, and then somebody else asks him later, I can be fair. So which one is it? Is it the first one or the last one? Which one do we go by?
Justice Lewis, to answer your question, we would point towards the fact that this was after the questionnaire took place and before voir dire. We would assert today that during voir dire, his statements were clarified, and after he made the statement that he probably could not be a fair juror, after being asked whether he could put aside any potential bias that he had, and after discovering the relationship, the distant relationship that he had with a roommate's sibling whose gender he could not remember, that he could be a fair juror.
What about the shared post? Talk about the first one. Doesn't that just, that kind of cries out? Why would someone be posting something like that unless they had an axe to grind?
Justice Kennedy, in regards to the shared post, we would equate it to being friends on social media. If you're friends with someone on social media, it does not necessarily mean that you are friends with them, or if you follow them, that you are literally following them. In the same way, we would assert that a share may be because you are pointing out the ridiculousness of something, or that you agree, or that you may...
But at the very time when he, at least the first one, when he's a prospective juror in a case that is related to the subject, at least indirectly to the subject of the post, doesn't that raise some real serious concerns?
Justice Kennedy, on page 24 of the record, after being asked about this shared post, Juror Stone stated that he shared this post because he liked the person who posted it, not necessarily because he reflected the same beliefs that they had. And in regards to clarify what a shared post...
What if the post had said that, I think that the parties in this case, the defendant in this case, is bad and guilty of all kinds of crimes against children, and he shared that. How would that work?
Justice Kennedy, to answer your hypothetical, we would concede today that in that case, Juror Stone may have been needed to be stricken for a cause strike, but in this case, the post did not mention the Wilderness Scouts or the defendant by name. It was a different scouting organization, and similarly, we would equate a sharing as if there's a news article about...
I mean, it's unavoidable to draw the conclusion that that this post was branding groups of this type as archaic orgs, right?
Yes, Justice Kennedy, but similarly...
And deserving of punishment, right?
Yes, but the trial had not taken place, and Juror Stone did not see the uniform that they were wearing, so there's no way that, as defense counsel asserted during that time, that he could have equated the uniform of the Wilderness Scouts to that uniform of that organization.
I think we're talking, though, even if you get by that the judge did not abuse his discretion in striking the juror at that time. Then the day before closing arguments, there was Mr. Stone again liking a third-party post on Faceplace that said these scouts are led by corrupt cult leaders that abuse kids and force the kiddies' parents to pay for it. So now we've got something, wasn't that first of all in violation of the trial judge's instructions not to read outside media, number one, and two, doesn't that meet the De La Rosa first prong that he didn't disclose it, and that it would lead a reasonable person to think this, maybe you thought so before, but now you know this was a biased juror.
Justice Periente, to answer your question, we concede that the first prong of the De La Rosa standard was met, but we believe that in regards to Juror Stone liking that post, that goes towards the third prong of the De La Rosa standard. Defense counsel waited until after the trial had been completed to mention this like that may have occurred.
Well, what if was there a hearing as to when the defendant first discovered the post?
The record is silent as to whether or not defense counsel knew, but this like had been made before closing arguments had occurred.
But you're talking about first, they tried to strike the juror, right? They had tried that, the judge denied it, even though maybe another judge would have granted it. But then, you saying that throughout a trial, that the attorneys are obligated to follow the social media of all the jurors? First of all, it seemed like an invasion of privacy, but is that something you would want attorneys to do?
Justice Periente, the third prong of the De La Rosa standard states that the failure to disclose the information was not attributable to the complaining party's lack of diligence. Therefore, if defense counsel found issues with just Juror Stone's social media posts, it's up to them to follow their due diligence to determine.
Excuse me, what was the lawyer supposed to be in the courtroom asking questions while he holds behind his head some type of computer checking during the trial? What's going on? And that was rejected in De La Rosa, wasn't it?
Yes, Justice Lewis. We would simply assert today that we are unable to determine whether or not that like reflected Juror Stone's belief due to the fact that defense counsel waited until the trial had completed, until they took a gamble and ended up receiving a verdict that was not on their side.
How can you assert that they took a gamble when you don't know whether they knew about it or not earlier?
The record does state that the like took place before the completion of the closing arguments, and although we are not sure, we are sure that defense counsel waited until after the verdict to mention.
But I think what our point is here is there hasn't been any obligation on the part of lawyers to be following the jurors that are picked, their Facebook posts during the entire time of a trial. In fact, it would seem to be sort of a concern if that was happening. I think jurors would start to feel like attorneys were looking into their private lives. So if you don't win on that issue, that is due diligence, don't you have a De La Rosa case here to require reversal on the issue of juror bias, actual bias?
Justice Periente, we would also assert that the second prong of the De La Rosa was not met, that there was not any concealment. Juror Stone plainly stated that he had a relationship with someone who was distantly affected by the scouting organization, but on page 24 of the record, he stated that this did not have any effect on his personal opinion. Similarly, as established in...
If he asserted during jury selection that he had no negative opinion of organizations like this, and the posts reflect that that is not true, why isn't that concealment of a relevant fact?
Chief Justice Lobataga, I see that my time has expired. May I briefly answer Justice Lawson's question and then conclude?
Sure, finish it.
To answer your question, on question 6 of the questionnaire, Juror Stone stated that he has no opinion as to the scouting organizations as a whole. We contend today that a share does not inherently mean an affirmation of belief, similarly to how a news article may be talking about the death of 50 people in an earthquake, and people may share that. Just because they share that post does not mean that they are in agreement with what has occurred, but it may mean that they want to share what a tragedy that's been. So because...
And a like doesn't mean agreement either?
We would assert today that someone may like, maybe a reciprocal like, as Juror Stone stated on page 24 of the record, he liked this post because he had an affinity for the person who had posted it. It is for the aforementioned reasons that we ask that this court reverse the decision of the 6th District Court of Appeal finding in favor of petitioner Ms. Frances Mallory.
Thank you.
Mr. Chief Justice, honorable justices, may it please the court. My name is Paridi Kapadia, my co-counsel is Madison Paez, and together we represent the respondent in this case, Taylor Smith. Of the two issues, I will address the first, which is whether the enforceability of a parental pre-injury release lies in its classification as a commercial or non-commercial enterprise. And my co-counsel will address the second issue, which is whether the trial court abused its discretion in failing to dismiss a juror for cause and denying motion for new trial. We would respectfully ask this honorable court to affirm the decision of the Sixth District Court of Appeal in finding that the directed verdict was warranted for the following three reasons. First, the Wilderness Scouts constitute a non-commercial enterprise. Second, respondent's intention to be waived from liability was clear and unequivocal. And third, the standard for a directed verdict was met in this case. As to the first issue, respondent would contend that the lower court was correct in finding that the Wilderness Scouts were a non-commercial enterprise. Statute 744-301 was enacted in response to this honorable court's decision in Curtin v. Fields in finding that exculpatory clauses as a whole were unenforceable when it came to commercial enterprises.
Let me ask you, what is the definition of a commercial enterprise?
Justice Quince, to answer that, the Florida courts have not set forth a distinctive test as to whether something is commercial or non-commercial. However, respondent would look to the Ohio Supreme Court's decision in Zivich v. Mentor Soccer Club, in which that court looked at a holistic analysis of the organization and determined the intent of the organization and whether the activity was in furtherance of that intent. Respondent would respectfully...
Your opponent argues that this was a commercial enterprise because they, in fact, charge a fee that a lot of people can't pay, and that therefore was, so tell me why that argument is wrong.
First, Justice Quince, this case is distinguishable from Keene v. Zoning Board of Adjustment, which petitioner relied on to establish that there was a test for whether something is commercial or not. Keene v. Zoning Board of Adjustment was a case about land usage and determining whether something was commercial land usage or not, and speaks nothing to the distinction between a commercial or a non-commercial enterprise in the context of exculpatory clauses being enforced on behalf of minor children. Furthermore, the Wilsons in that case operated specifically to personally enrich themselves, whereas here the only demonstrated intent of the Wilderness Scouts was to provide educational and recreational opportunities. Respondent would look to the Ohio Supreme Court's decision again in Zivich v. Mentor Soccer Club, in which the court there found that just because an organization collects certain minimum mandatory fees or uses those fees to pay administrative costs, including salaries, does not automatically make it a commercial enterprise. Rather, there are several organizations such as the Little League or the Boys and Girls of America, in which their employees are paid. However, simply paying them in order to keep the operation ongoing does not automatically make them a commercial enterprise.
Is it a question of law or a mixed question of fact and law? There's facts in here that they operated an online retail store where the uniforms and other camping gear could be purchased by the public. So the trial court found that it was commercial enterprise, correct?
Your Honor, the trial court made no determination as to whether it was commercial or non-commercial.
Well, but the assumption would have been that if it was commercial, then we got to look at release, at the language. If it's non-commercial, then the release form doesn't have to comply with the statute that was enacted after our decision.
Yes, Justice Perrin.
So if we assume that it has aspects of being commercial, then don't we go to the fact that the release in this case did not comply with the statute subsequently enacted that requires bold-faced notice of what they're releasing, and also it doesn't release negligence, it releases inherently dangerous activity. So I guess if this decedent was killed by a tarantula, that would be sort of part of going camping. But being consumed in a fire, and we don't, again, know the circumstances, is not what we would normally think about as part of the inherent risks of going camping. I hope not, at least.
Justice Periante, to answer your question, if this court were to find that the Wilderness Scouts are a commercial enterprise and that the activity dealt with inherent risk, then only would the exculpatory clause have had to comply with Statute 744-301, which respondent concedes that the exculpatory clause did not. However, respondent would contend that there are no disputed facts in the record that would go to support a finding that the Wilderness Scouts are in fact commercial. In response to the fact that it operated an online store, respondent would emphasize the fact that there is nothing in the record that would go to support petitioner's position that the operation of the online store affected the Wilderness Scouts' status as a nonprofit organization. Furthermore, we would emphasize that this case is more comparable to the Mentors Soccer Club in Zivich versus Mentors Soccer Club, or the Fire Rescue Training Program in Gonzalez versus City of Coral Gables, whereby the courts found that those organizations operated for a specific recreational or educational purpose, and therefore, since the activities were in furtherance of that intent, they were non-commercial enterprises.
But it seems like there's a mixture of whether something is for-profit or not, and whether it's commercial or not. Aren't those two separate things?
Yes, Justice Polson, respondent would acknowledge that making something for profit and something commercial are distinctive. However, that is a factor in considering whether it's commercial or not. And since the Wilderness Scouts were a nonprofit entity, respondent would contend that that is a major factor to be considered in whether it's commercial or non-commercial.
How do we distinguish those? What are the differences between a commercial and a for-profit?
Justice Polson, respondent will contend that for-profit and commercial enterprises, while they are not the same, they do offer a lot of insight into what is a commercial enterprise, and if an organization is operating for profit and operating not for an educational or recreational purpose, respondent would contend that that would be a major factor that this court would have to consider in whether something is commercial. But either way, the Wilderness Scouts were a nonprofit organization, and any fees they collected would go to offset administrative costs. As to our second argument, respondent would contend that the exculpatory clause was clear and unambiguous and therefore met the common law standards set forth in Brooks versus Paul. And in that case, the 4th District Court of Appeal stated that when an exculpatory clause attempts to waive negligence, as the statute 744-301 allows non-commercial enterprises to do, they must meet the common law standard of having clear language that demonstrates a clear and unequivocal intention to be waived from liability, such that an ordinary person would know what he or she is contracting away.
Well, it seems to me, if you look at the waiver, the first section clearly says, I'm authorizing you to give medical attention to my child if something happens, and every parent's going to make sure, because they're not going to want to wait until they try to get a hold of them. So there's that. But then in the same small language, we then have it's releasing them from everything. And now it seems to me, and maybe it's because is that they're agreeing then that camping is inherently dangerous and you're assuming the risk of that activity. I don't know why that is. It's read would lead a parent to think that they were releasing your client from negligence on the part of the employees of the organization. I guess what I'm disagreeing with is whether this is in fact so clear and unambiguous. How would you compare it to other releases? And it just seems to me that if you look at the first paragraph and the last, you think you're sort of saying, yes, we know camping's inherently dangerous and I want to give medical attention, if needed.
Justice Pariente, to answer that, respondent would direct this honorable court's attention to this honorable court's decision in Sanislow versus Give Kids the World, in which the court found that in order for an exculpatory clause to be enforceable, there need not be specific words or phrases included in it in order for it to be enforceable to a specific cause of action. And in that case, this honorable court found that the exculpatory clause was still valid as to the cause of action of negligence, even though the word negligence was not specifically mentioned. Furthermore, respondent would draw similarities and compare this case to the cases of Hardage Enterprises versus Fidices Corporation, as well as Lance versus Iron Horse Saloon and the Greater Orlando Aviation Authority versus
But
Bulldog
even if
Airlines.
we accept all of that as being applicable and controlling, the release does not state facially that it releases volunteers, does it?
No, Justice Lewis, in the
Now,
exculpatory
isn't there a
clause.
difference between an employee and a volunteer?
Yes, Justice Lewis,
And the defendant here is totally volunteer, no dispute.
Yes, Justice Lewis. However, respondent would contend that per the analysis in Stanislaw versus Give Kids the World and per the policy considerations, when an ordinary person would be viewing this contract, the court must take into consideration the intent of both parties against the background of other indicia. Your Honor, I see that my time has elapsed. May I have a moment to briefly conclude and answer Justice Lewis's question? As per the reasoning in Stanislaw versus Give Kids the World, we must look at the intent of the parties, and when looking at the intent, respondent would contend that it is clear that the exculpatory clause would be rendered meaningless and ineffective if we were to not consider Taylor Smith as covered under that employees or under the exculpatory clause. And for those aforementioned reasons...
Well, I mean, even though it says employees, it doesn't say volunteers? It's like it would apply to anyone we think it should then.
Justice Lewis, respondent would contend that respondent was the intended beneficiary of this exculpatory clause, as he was the one who required petitioner to sign it, he was the one who gave it to petitioner, and he was the only one who would be chaperoning this trip. And in the context of that, respondent would contend that if he were not to be considered someone who was covered under the release, then the release would be rendered ineffective and meaningless. And for those reasons, we respectfully ask this honorable court to affirm the decision of the 6th District Court of Appeal and find that the directed verdict was warranted. Thank you.
Thank you.
May it please the court, good afternoon, Mr. Chief Justice, honorable justices. My name is Madison Paez, and I will be discussing issue 2, which is whether the trial court abused its discretion in refusing to dismiss a juror for cause based upon concealment of information and bias, and whether the court should have granted a motion for a new trial. We respectfully ask this honorable court to affirm the ruling of the 6th District Court of Appeals for the following 3 reasons. First, the trial court abused its discretion in failing to excuse Juror Stone for cause based upon bias and partiality. Second, the trial court abused its discretion in not granting a motion for a new trial based upon concealment of bias. And third, Juror Stone's use of social media violated Smith's constitutional rights. With respect to the first argument, the respondent does concede that the standard of review is an abuse of discretion, which asks whether reasonable people could differ as to the propriety of the trial court's ruling. However, the respondent asserts that reasonable people could not differ as to the propriety of the trial court's ruling, since the trial court unreasonably concluded that Juror Stone did have the ability to render a fair and impartial verdict. We utilize the legal standard that this honorable court set forth in Singer v. State, which asks whether there is reasonable doubt as to a juror's impartiality, which would enable them to render a fair and impartial verdict. And in that case, this honorable court concluded that the failure to strike Juror Shaw was an error, where he stated he might be able to put aside we had heard about the case and gave several contradictory responses. And we assert that Singer v. State is analogous to the instant case in the way that Juror Stone raised his hand and stated he couldn't be fair and impartial, and later went on to share a highly inflammatory social media post depicting a tarred and feathered scoutmaster with the caption, "An archaic punishment for an archaic organization."
That's the one, that was the post that occurred during jury selection.
Yes, Justice President.
So your first argument goes to that when during jury selection, the trial court should have excused this juror because there was a showing of actual bias.
That is correct, Justice
And there's no
President.
question it was preserved because they had exhausted all their peremptory challenges.
Yes.
Okay, so what's the conflict? If he's talking about another situation, he doesn't know about this case, where is the bias shown in the initial comments by this juror?
Justice Periente, I would like to point this court to the fact that we must analyze the totality of the circumstances when determining whether or not Juror Stone should have been stricken for cause, and when we look at everything in the context of the situation and place Juror Stone's statements both inside and outside of court. It is no coincidence that we're dealing with a case about a respondent who is a scoutmaster in a scouting organization, and that this shared post depicted a tarred and feathered scoutmaster. And as a
The juror actually explained in answer questions about this particular post, correct?
Yes, Justice Lawson.
And the trial judge was in a position to be there and to witness the demeanor of the juror and to consider the explanation, and apparently found the explanation as to this particular post credible. And why shouldn't we defer under the abuse of discretion standard to the trial judge's finding with respect to that post? We weren't in the courtroom. We didn't hear the explanation.
Justice Lawson, we do concede that deference to the trial court is given. However, it is important to understand that that deference is not unlimited and it is not absolute. In fact, we look to this honorable court's decision once again in Singer versus State as well as Johnson versus Reynolds, where the actions of the trial court were reversed, where they acted unreasonably in not striking a juror for cause. In Johnson versus Reynolds, Juror Scott knew plaintiff's counsel and initially stated he couldn't be fair, and then later changed his mind and said he could, which is exactly what took place here. Despite that, this honorable court ultimately concluded that one's last statement is not more worthy of belief than the former, and we assert that the reasoning applied in Johnson versus Reynolds is seamless to the instant case. Just because Juror Stone did later say he could put those feelings aside, the fact that he initially raised his hand and stated he could not be fair would create reasonable doubt as to his ability to be fair and impartial. The last case we look to is a
But
fifth...
you know, under those kinds of circumstances, you're saying that a juror who initially says something cannot be rehabilitated?
No, Justice Quince. We do concede that a juror can be rehabilitated. However, when analyzing the instant case and looking to the totality of the circumstances, and once again...
Well, at that point, though, we're talking about just initially at the voir dire stage. Wasn't he rehabilitated?
No, Justice Quince. In fact, this honorable court in Singer versus State on page 24, headnote 15, stated that a juror's statement that they can be fair and impartial is not determinative of their competence, especially when contradictory statements are made. And as a result, because Juror Stone here did give several contradictory responses as to his feelings about scouting organizations and scoutmasters, there was reasonable doubt as to his ability to be a fair and impartial juror. The last case...
And again, I guess this is, as I look at this, he first said he couldn't be fair. Then he explained why, which is that he had a brother or sister who was abused by a scoutmaster, and he knew, you know, the bullying affected you in a negative way. I'll never forget it. So we're now talking about some pretty specific statements, and that's what you're relying on. So I'm trying to think of what do you think the judge did to see something different about what that, even though the juror said later he could be fair, how, in light of those statements, I mean, is there anything else we're missing on those initial changes?
Justice Periente, once again, when we look to the totality of the circumstances, Juror Stone first raised his hand and stated he couldn't be fair and impartial. Then he went on to share this highly pejorative post and later liked another post stating that all scouting organizations are corrupt and deserve to be banned from the planet. And at that point, it was clear that there was substantial reasonable doubt as to his ability to be a fair and impartial juror. And as a result, the respondent asserts that the trial court did abuse its discretion in determining that he would have been able to do so. With respect to our second argument...
Will you address the argument that that was not timely raised? The third post should have been raised during trial, before a verdict.
Justice Lawson, I would point this court to this honorable court's decision in Roberts versus Tejada, where in fact Justice Lewis expanded upon this analysis and stated that when we balance the integrity of the judicial process against the burden on the system and the cost of granting these motions for new trials, the integrity of the judicial and juror process should not be sacrificed in the name of expediency, and as a result, it would have been unfair to impose these obligations on counsel to bring this up the night before closing arguments.
Well, there's no knowledge, there's no evidence that counsel knew about it before closing, or is there?
Yes, Justice Periente.
What, there is not, that he knew about it or didn't?
No, Justice Periente.
But you were, and again, there was, the second point was, after he made these statements, the next day they found, while jury selection's still going on, they find this other post.
Yes.
So they timely preserved that, and the judge still doesn't grant cause. So did the judge give a reason as to why they didn't give an extra peremptory challenge for this juror?
Yes, Justice Periente, the trial judge cited 2 reasons as to not striking this juror. 1, that the relationship was tenuous, and 2, that the juror could not remember the gender of the sibling. However, the respondent would assert that these 2 facts are irrelevant when considering Juror Stone's state of mind, and what the court should have focused on was his bias and how these posts infected his state of mind and his ability to render a fair and impartial verdict. With respect to the first prong of the De La Rosa test, the petitioner conceded this at both the trial and appellate court levels. Therefore, the respondent asserts that the first prong has been met. The second prong deals with concealment and mandates that the juror concealed bias and information during questioning. The petitioner pointed out that Juror Stone did make his experience regarding Scoutmasters explicit. However, what he failed to disclose was his innate bias regarding Scoutmasters, and as a result, the respondent. Additionally, on question 6 of the questionnaire, Juror Stone indicated that he had no opinion of Scoutmasters, but later went on to like this highly inflammatory and pejorative posts indicating otherwise. With respect to the third prong, this honorable court stated that the failure to disclose information should not be attributable to a lack of due diligence on counsel's part, and the respondent asserts that especially when looking to Roberts versus Tejada, there was not any lack of due diligence, as it would be unreasonable to impose these obligations, and it would create a chilling effect across the state of Florida and ultimately be cost prohibitive for everyone in the judicial process. With respect to our third argument, we contend that Juror Stone's use of social media did violate Smith's constitutional rights. The petitioner utilized Murphy versus Roth. However, we contend that that case is distinguishable from the instant one. In that case, the juror indicated that he was not too fond of jury service, and as a result, the court deemed those statements benign and not prejudicial. However, in this case, it is clear that Juror Stone's social media posts showed a predisposition against the respondent and an innate bias against the respondent in this case. The court in Murphy versus Roth actually relied upon a United States court decision, United States versus Fumo, in which the court set forth a test and stated that the only way in which a new trial should be warranted is if there shows a predisposition against the respondent. And in that case, in this case, there clearly was a predisposition. Your Honor, I see that my time has expired. Permission to briefly conclude?
Sure.
Thank you. So therefore, because Juror Stone exhibited a clear and innate bias and prejudice against the respondent, and all 3 prongs of the De La Rosa test have been met, and Juror Stone's use of social media did violate Smith's constitutional rights to a fair trial, we respectfully ask this honorable court to affirm the ruling of the 6th District Court of Appeals and remand for a new trial. Thank you.
May it please the court. As Justice Periente said, the waiver in question only waived inherent risk, something more in line with poison ivy or tarantula bite, not a fire that was determined by the trier of facts to be a result of negligence. Additionally, going to Justice Lewis's point, the waiver did not release volunteers, only employees. And page 20 of the record is very explicit in stating that Scoutmaster Smith was strictly a volunteer and not an employee.
Let me ask you why you say that the release only released inherent risks when it clearly says it releases from any and all liability claims, demands, causes of actions, and possible causes of actions arising out of or related to loss, damage, injury, etc. I mean, it by its express language, that part is broad, and would it cover negligence or uninherent risks, wouldn't it?
Justice Lawson, we would point to this court's reasoning in San Eliso in order to set the standard that it's the totality of the waiver, whether or not a reasonable person were to believe what they're waiving is any and all claims. This is confirmed by Florida Statute 744.301 that it's only enforceable when it waives inherent risk. Furthermore, as established in Canarcus v. Canarcus, a trial court has a superior vantage point, which goes to Justice Lawson's point in determining whether or not a juror really has bias. The trial court stood in front of Juror Stone as close as I am standing in front of this honorable court today, and was able to listen to the inflections in his voice, see his facial expressions, and see his body language in result to the questioning and the posts, and made the determination that he was not biased. For those reasons, we ask that this court reverse the decision of the 6th District Court of Appeal.
Okay, thank you. Thank you for your arguments. We're now going to go and deliberate.
All rise.